On June 7th, the U.S. Court of Appeals for the Ninth Circuit had a decision that really got conservatives very excited. It was in a vaccine case. The case is called Health Freedom Defense Fund, Inc. v. Carvalho. I think I'm pronouncing that properly. But in any event, it's a group of plaintiffs against the LA School District challenging a mandatory vaccine policy. And the case history is kind of interesting. The policy was implemented in 2021, and a group of plaintiffs sued at that time. And right after they sued, the school district put out a memo that allegedly clarified the policy, permitting people to show proof that they didn't have COVID-19 to circumvent the mandatory nature of the mandate, and that they got the case thrown out as moot because they were able to say, look, it actually isn't an absolute mandate. And then shortly thereafter, they reimposed the mandate on everyone. So a couple of years go by, and a mixture of the original plaintiffs and some new plaintiffs have brought suit again because as insane as this is, they still have a mandatory vaccine policy in this school district, as apparently a lot of places do. And so they brought suit again, and this time the school district brought judgment on the pleadings, arguing that the vaccine is safe and effective. And in any event, it went to the district court. The district court applied Jacobson, which if you track these vaccine cases, you know Jacobson is a 19th century vaccine case that I think is misapplied all over the place and is the subject, frankly, of significant academic discussion, but that's the subject of a different video. But the court applied Jacobson and dismissed the suit again. So they appealed to the Ninth Circuit, and the appeals process, of course, is you notice appeal, you brief, you go to oral argument if oral argument is called for, and then the panel decides the issue. And so what happened was they briefed, they went to oral argument, and at oral argument, the questioning from the judges was pretty intense, apparently, and it was kind of clear, it sounds like, to the litigants that the panel was going to probably move in favor of the plaintiffs. And therefore, that very same day, the school district withdrew the policy. And then they claimed, oh, it's moot again, you have to dismiss this case as moot. And to give the Ninth Circuit a lot of credit, the judges said, no, 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 and pointed to the duplicitous past that this case already had, the times that the case was brought, and then they dropped it, then they reinstated it once the case was over. Now they're trying to do it again, and they said you can't use that to circumvent the courts. And so actually the lion's share of this decision that came down on June 7th is discussing that mootness issue. When they finally get to the merits, what I want to point out is initially what the standard of review is. And the standard of review in appellate cases is always so important to the disposition of whatever the appeal is. And here, I'm just going to read it for you. Judgments on the pleadings are reviewed de novo. We review under the same standards as motion to dismiss. So we must accept the plaintiff's alleged facts as true, whether actual proof of them is improbable. And, I always say that is so important at the motion to dismiss stage. Sometimes you can get a really great decision on the motion to dismiss, and then down the line, it's not going to be so great, because the idea in court is we do want to weed out early on cases that have absolutely no merit at all. And so we do have that motion to dismiss where you can get a case thrown out early on. But we try to keep the bar kind of low because we want people to be able to get into court and get their day in court and get discovery and have justice be done. So it's sort of a balancing act in the courts, but typically at the motion to dismiss stage, it's a little more complicated than this, but for purposes of this discussion, the plaintiff's facts as pled are taken as true. And then down the line, though, when that standard changes, a lot of things can change. And that's basically what the court says here. They run through on the merits issue. They say, let me just get down to it. It's right down here. They look at what the district court decided. In Jacobson, the Supreme Court balanced an individual's liberty interest in declining an unwanted smallpox vaccine against the state's interest in preventing disease. And what the plaintiffs have argued in this case is that it's not a vaccine at all. It's just a medical therapy. And so the court must take that as true, and it determined that Jacobson was therefore misapplied in this case, and they vacated and remanded to the lower court to reconsider under the proper standard. Now, as this goes through the courts and they present more evidence and there's more dispute, at some point the court could decide that Jacobson actually does apply to this case. It's just at this first motion to dismiss stage that they're going really easy on the plaintiffs and taking everything they say as true. And the court explicitly notes this. It says, and I quote, "At this stage, we must accept plaintiffs' allegations that the vaccine does not prevent the spread of COVID-19 as true." And then again, a little farther down, they say, they're very explicit. "We note the preliminary nature of our holding. We do not prejudge whether, on a more developed factual record, plaintiffs' allegations will prove true. But whether an action can be dismissed on the pleadings depends on what the pleadings say. Because we must accept them as true, plaintiffs have plausibly alleged that the COVID-19 vaccine does not effectively prevent the spread of COVID-19. Thus, Jacobson does not apply, and so we vacate the district court's order of dismissal and remand." So it's a good decision insofar as the court did not let the school district be little weasels and get out of this case by mooting their mandate, which they've done in the past and then reinstated it. And it's also good that they applied the standard as they should in favor of the plaintiffs. But it does not mean that down the road everything could change. And I don't think it's proper or factually accurate to say that an appellate court, or this court in particular in this case, has held that the vaccine is not actually a vaccine. All they're saying is that's what the plaintiffs pled, and at this stage legally, that's therefore what we must hold for the purposes of this appeal. So it's, as I say, it's a mixed bag. It was a good decision, but it doesn't go as far as a lot of people seem to think it goes. But it's certainly a good reminder that there are vaccine mandates all across the country, and we as the grassroots need to look at the state level, at our state legislatures, how we can roll these back and really entrench some protections for people, because although a lot of places, certainly where I live and maybe where you live, COVID-19 is a thing of the past, we know we will have these issues come up again, and we need to have the legal implements in place to defend ourselves in the future.